There you
go. I'd like to start again just by echoing the thanks that have been given to the organizers of this conference. So to dive straight into my presentation, the main concept is that of waste. And waste is really a huge issue, mainly because there's numerous statistics out there of how much waste we produce, both at UK level, EU level, and on an international level. And this really is such an issue as a result of the current waste management options at the moment. And landfill is a huge one, as is incineration, that both have huge negative environmental, economic, and social implications. Waste is also linked to our current resource crises, because waste provides an option of addressing the resource crisis at the minute by thinking about waste as a potential resource. And that's really what my research focuses on. And it focuses on a concept called industrial symbiosis. I've defined industrial symbiosis as engaging traditionally separate industries and other organizations in a collective approach involving physical exchange of waste and byproducts, resulting in economic, environmental, and social benefits. So this is quite a lengthy definition, and it's best understood by looking at the diagram. This is the seminal example of industrial symbiosis in Kalundborg in Denmark. And so each green icon is an organization, mainly industries in this example, and each line, the pink or the blue, is an exchange of some waste or byproduct. So, for example, Statoil there produces waste heat that it sells to the local energy producer, Gong Energy, and it uses this in its desulfurization process to produce energy. And this process, it produces gypsum as a byproduct, and it sells this in turn to the local plasterboard company because it's a raw material. So this sort of system has huge economic, environmental, and social benefits, or potential benefits depending on the context, because they are the organizations involved do reap an economic benefit. There's also reduced greenhouse gas emissions because there's reduced transportation of virgin materials that would have otherwise have to be imported in many cases. Social benefits include job creation. Also in Kalundborg, there is a lot of pride on a local level of the system being in their town. This is just quantitatively showing some of these potential benefits. There are some disadvantages. I won't go into much detail, but it doesn't necessarily discourage the production of waste. It's just a strategy to potentially deal with waste. Also, it does depend on the local context. So these benefits won't necessarily be the same in each context. You would need to do a life cycle assessment in each case to see what the potentials are. And so in this presentation, I'm evaluating the effectiveness of regulatory and policy frameworks affecting the initiation and sustainment of existing industrial symbioses. It will be quite high level, but I'll be happy to discuss more in detail over lunch if anyone's interested. And so I'm mainly looking at what it means to evaluate effectiveness, and then also just looking at specific case studies. And my case studies are the Humber region and in the UK, and then Kalundborg, just because it is the seminal example and is a really useful comparison. So evaluation doesn't have a single definition, but this are the main definitions I've identified following a literature review. And I'm mainly concerned with the first three and really focusing on whether goals and objectives have been achieved. And in terms of my definition, this is in terms of economic, environmental, and social benefits that are being reaped by industrial symbiosis through the use of the implementation of industrial symbiosis system. Effectiveness, again, doesn't have one definition, but here I've taken it to mean whether goals and objectives have been achieved. The final two are really important elements as well, particularly in industrial symbiosis. Something that I don't really touch upon that much because I'm looking at the regulatory aspect, but the economics of industrial symbiosis is really important. None of these organizations would be involved if there wasn't some economic merit or worth or value to these organizations. The environmental aspect is often just an additional bonus to these organizations. This is just the system I'm using to look at these industrial symbiosis systems. It's the Institutional Analysis Development Framework as was developed by Ostrom, Gardner, and Walker, but I've adopted it slightly to fit to this system. And it's just industrial symbiosis is a very multidisciplinary topic. It is a topic that mainly originated in engineering fields. So in order to not get too focused on the regulatory aspects, even though this is central as it's a PhD in law, it's important to remember that there's all these components contributing to the industrial symbiosis system. And I'm particularly concerned with rules and use, which is where regulation policy both come in. So both case studies I'm looking at a couple more in my thesis, are in the EU. And the Waste Framework Directive is essential to this because, as I defined industrial symbiosis, waste and byproducts are the key products. And so the relevance of this is the objective of the Waste Framework Directive is to protect the environment and human health. And one of the ways is through improving the efficiency of the use of resources. So this is really where industrial symbiosis can provide possible strategy to help achieve the aim of the Waste Framework Directive. Now, central to the directive is the definition of waste, which is any substance or object which the holder discards or intends or is required to discard. Now, there's a huge amount of case law on this at EU law, and that's because there's a lot of uncertainty about the definition of waste. This uncertainty has resulted in some sort of certainty, actually, because whenever there's uncertainty whether something is waste or not, it's always classed as waste just in order to take that precautionary approach. So there is, even though they always say it's very uncertain, it is certain in that way. And this has implications for industrial symbiosis, because if something is classed as waste, there's a number of waste requirements that follow, and these often have financial implications, and most of these are to do with permits. So in order to transport the permits between organizations to deal with the waste, you need permits for each of those, and that comes with financial costs. So this is an often cited barrier to industrial symbiosis. Then there is the extended producer responsibility, and that's essentially where the producer of a substance or object maintains responsibility. And a useful example of this is the example of Xerox, that was an early adopter of the extended producer responsibility before it was even included in policy or legislation. And this is that they lease their photocopiers to their clients, and then instead of selling them, it would be a lease, and when the product broke, it'd be returned to them, they'd repair it or a component, and the client would be provided with a new component. So it's thinking about ownership in a different sort of way as well. And so that Xerox maintains that responsibility for the waste that comes out of their products. And so this really resonates also with some of the concepts in industrial symbiosis, and it can almost be seen as a manifestation. If these industries are given more responsibility for their waste, really incentivized to think more about waste and byproducts in a more cyclical way. There's also other relevant EU law out there. The landfill directive is also very relevant, and that's as a result of the landfill tax. This has had this is dependent on the context. In some cases, it's been an incentive because the landfill tax has been so high that companies have wanted to avoid that tax and instead think of how else to use their waste. But in other cases, the landfill tax hasn't been quite high enough to really incentivize this change. There's also numerous policy documents. The first two explicitly mention industrial symbiosis and how really is a strategy that should be pursued by member states in the EU. And then the circular economy package that was recently revised is also relevant because, again, it's thinking more about that cycle of products and resources. Anything that's put in comes out of a system that's put back into the system, and there's all these loops. And then finally, recently, there's been a European Industrial Symbiosis Association set up. This has had limited impact so far, but because Horizon 2020 has included a number of research projects on industrial symbiosis, also with this revised circular economy package, there is more potential. They'll have a bigger role to play. So now looking first at Kalundborg. So there is the Danish planning law at national level, and this sets out that municipalities set out local Agenda 21, so how municipalities intend to contribute to sustainable development. And this has been quite crucial in the sustainment of industrial symbiosis in Kalundborg, because in their strategy, which is called the Kommuneplan 2013 to 2024, industrial symbiosis has been a key strategy. So by including it at their local level documents, they're really encouraging the continuation of this concept. And this has really been a key issue in many circumstances where the thought or the idea of the concept is there, but then to continue with it and maintain these exchanges is also, there's technical developments is important. It's been integrated into their system. Third parties have also been really important. The Danish Business Authority on a national scale has just recently finished a project on industrial symbiosis and how to implement it elsewhere in Denmark. And also the Symbiosis Center, which is really key to helping companies that want to engage in industrial symbiosis understanding how they should do. There are disadvantages to the current system, and that is there's a lot of flexibility in the law because a lot of it's been given the responsibility has been given to the municipal level and the local level. There's less of a stringent compliance and enforcement mechanisms, but at the same time, this flexibility has helped. So there are these trade-offs that need to be considered. This is just a diagram of the Humber region and some of the networks there. And again, just the smaller table also already indicates that there's less of a focus of industrial symbiosis, both at national and local level within England. So there are the environmental permitting regulations, but the main way this has contributed is that it's set out landfill targets. And there is this concept of shared responsibility where consumers, producers all need to start thinking more about what to do with their waste, but there's no real action regarding industrial symbiosis at national level. At municipal level, the Humber region does have an economic plan, but unlike Kalundborg, they've not really taken advantage of this industrial symbiosis concept. They've mainly focused on resource efficiency more widely, but they've not highlighted specific strategies that have proven to be a success. There are, again, third parties involved. The Environment Agency has been really crucial in the Humber region. And then there's also the National Industrial Symbiosis Program. And this is really highlighted in a lot of industrial symbiosis literature as really a key organization. But unfortunately, there have been funding issues, so it's been quite an uncertain future for NISP, but it's again on the way up and could provide a platform for more symbiosis exchanges. Here in England, the main disincentive has been highlighted as the landfill tax. For one of my other case studies, actually, in Sweden, they receive 65% of their waste that they use in their industrial symbiosis from England, because the landfill tax is very high here, but it works out that it's cheaper to export all their waste, not all their waste, but a chunk of their waste, and then send it to Sweden, and that's also the most economic efficient way, which shows that a lot of it's driven by business rather than environmental concerns. So these are some recommendations. I am still working on my thesis, so it's an ongoing, it's a work in process. But one of the key things that's come out from many of my interviews is also the redefining the concept of waste. So in Denmark, when I spoke to industrial representatives there, they really avoid the term waste at all, and they speak about resource efficiency. Also with the Danish Business Authority and their policy documents they are intending on producing, the emphasis is on resource efficiency rather than waste. Also, what has been key in both the case studies is this multi-level, multi-actor interaction. So the local level is really crucial. So it's not just a top-down system we're looking at, but how to complement the top-down with the bottom-up system where you perhaps have targets, but then where the lower level is given more flexibility to implement these policies that can really drive some of these strategies forward. And this is very reminiscent of new governance, the regulatory theory. There's also flexibility in law. This is also a tricky concept because with flexibility, there are concerns of legitimacy, compliance, and those are really issues I need to look at some more. And then just to place this in my further research, I'm looking at 2 more case studies in Europe. It is a European Union-based research thesis. And then I'll hopefully refine my recommendations a lot more as well. There'll be a lot more emphasis on regulatory theory as well, particularly this top-down and bottom-up, and flexibility is what I'm really interested in. And then finally, property rights is not something I've touched upon here either, but this has been also a key incentive in some areas. And I'm particularly looking at Ostrom's concept of common pool resources. Yeah, and that's it.
Thank you very much, Katrien. Another excellent paper. Okay, we only have 3 it seems, unless so you have we collected 10 extra minutes there. You can speak for 25. I'm only kidding.
Try.
So we have our 4th speaker, and our final speaker is James, whose surname I'm going to find in 2.5 minutes when I scroll down here. Where are we? Yes. So James is from the University of Lincoln, James Kunz, and you were speaking about the adoption of an ecocentric approach by international, or perspectives by international courts and tribunals.
Okay, yes. My name's Jamie Kunz. I'm a PhD candidate from the University of Lincoln. My thesis is looking at the role of courts and tribunals in the development of international environmental law, and specifically whether environmental objectives could be better served if international courts and tribunals moved further towards the incorporation of ecocentric perspectives in their jurisprudence and procedures. So today I want to specifically focus on the concept of sustainable development, which has been a key idea in the field of international environmental law over the past 30 years. And it's closely related to the anthropocentric conception of environmental protection. First, I want to look at the increasing prominence of environmental ethics as a response to the growing ecological crisis. This thinking developed out of the growing ecological conscience of the 50s and 60s, and work such as Rachel Carson's Silent Spring has often been identified as key touchstone and influence here. So environmental ethics looks at the nature of the human-nature relationship. The anthropocentric perspective places humanity at the centre of existence and has often been linked to the Western philosophical tradition, and often the idea that man is separated from nature and superior to nature, giving him dominion and control, and nature just basically becomes seen as a resource for his use. The environmental ethics movement is often framed as a reaction against this worldview or a criticism of it. And it's argued now that there are two perspectives, the anthropocentric and the non-anthropocentric or ecocentric, although it's probably more useful to think of this as a spectrum rather than an either-or distinction. Certain commentators argue that there's a fundamental contradiction between the two, but that is a debate for another day, maybe. So ecocentric perspectives question the assumed moral superiority of human beings and investigate arguments for assigning intrinsic value to the non-human world. And there's often a distinction in terms of value made between instrumental value, nature seen as a resource, versus intrinsic value, where value is placed or found in nature. And key texts in the ecocentric environmental ethics movement often identified as Aldo Leopold's Land Ethic and Arne Ness's Writing on Deep Ecology. So in terms of international environmental law specifically, Alexander Gillespie's done a lot of work in this area and has noted that there's no one dominant philosophical value, whilst noting also that anthropocentric values appear to be more common. And he's identified various rationales splitting these between anthropocentric and non-anthropocentric. So there's self-interest, which could be related to the idea of state sovereignty, cultural, economic values, which obviously can be linked to sustainable development, and aesthetics. And he contrasts these to the non-anthropocentric values of humane considerations, so values placed in animals, intrinsic value placed in animals, existence values, thinking about the nature of all beings, not just humans, and ecosystem values, looking at a more holistic conception. In the legal field, work such as Christopher Stone's Should Trees Have Standing and the Wild Law movement encapsulate these thinking. So if we look at the development of international environmental law, it's often traced back to the early 1970s and the Stockholm Convention. And Principle 1 places emphasis on the human right to a quality environment, so a very anthropocentric conception of what environmental protection should be, but also does note that, man's responsibility to protect and improve the environment for present and future generations. Over the last 30 years, the concept of sustainable development has taken a primary role in international environmental law, and the classic definition was set out by the Brundtland Commission in 1987. And that was sustainable development as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. And it's often related to concepts of intra and intergenerational equity. So the needs of the current poor in the world versus the need to ensure that we leave a suitable environment for future generations. And the concept's often framed in terms of balance, so between environmental concerns and economic concerns and social concerns, and as I said, poor versus future generations. The 1992 Rio Declaration took on thinking of sustainable development and placed it at the centre of international environmental law, the International Environmental Law Soft Law framework, and explicitly stated that human beings are at the centre of concerns for for sustainable development, so confirming the anthropocentric focus of the concept. And that was built upon in 2002 by the Johannesburg Declaration, which discussed three pillars: the social, economic, and environmental pillars. So looking at how the international courts and tribunals have engaged with these concepts, there's been a lot of jurisprudence over the past 20 to 25 years, much more than in the previous 100 years before that. In the advisory opinion on nuclear weapons in '96, the ICJ confirmed the general obligations of states to ensure activities within their jurisdiction and control respected the environment of other states or areas beyond their control. Links back to the fundamental principle of state sovereignty, which echoes Principle 21 of Stockholm and Principle 2 of Rio. And going back to Gillespie's values, you can link this to self-interest and economic values. Moving on, in the Gapchikovo-Nagamaras case, this concerns disputes between Hungary and Slovakia on the 1977 treaty, on the construction and joint operation of the barrage system. Here, the ICJ again confirms the position regarding transboundary damage and started to engage in discussions regarding newly developed norms of environmental law. While the language appeared to fall short of confirming sustainable development as one of these new norms or standards, the court did discuss it in some detail, and the idea of the need to reconcile economic development with protection of the environment being encapsulated in the concept of sustainable development. This can be contrasted with the separate opinion of Judge Weir-Mantry, who went a lot further and argued that sustainable development should be part of modern environmental law due to its logical necessity and general acceptance. And this position that was later echoed in a arbitral tribunal decision on the Iron Rhine Railway. In his separate opinion, Judge Weir-Mantry spoke a lot about traditional legal systems when considering the relationship between development and conservation, and took examples from Africa and Asia to suggest that sustainable development was a long-standing principle of sustainability that was now encapsulated in this definition of sustainable development. In the Pulp Mills case, more recent case from 2010, the court again engaged with the idea of sustainable development. This was a dispute under the 1975 statute for the River Uruguay concerning the construction of 2 pulp mills and a port facility. Here, the court placed a lot of emphasis on procedural requirements, so the duty to notify and the requirement to undertake an environmental impact assessment when there may be significant adverse impacts in the transboundary context. And interestingly, although the statute was from 1975 and predated the concept of sustainable development and its place in international law, the court read sustainable development into its interpretation of the treaty provisions. So, looking at sustainable development, it's obviously inherently vague and often used as a policy tool, and it's been criticised on that basis, and also that's seen partially as a slight advantage in that it can mean all manner of things. Also, it's been criticised on the basis that it often seems to favour development whilst paying mere lip service to environmental concerns. As Balin said, the concept should or must be perceived as incorporating both anthropocentric and ecocentric concerns. It can't focus on what, just on humans. There should be an environmental core. And arising out of this, the German academic Klaus Boselman calls for the development of ecologically sustainable development as a means to ensure intergenerational equity. And he says it needs to move away from its anthropocentric focus, which is creating uncertainties as to what human needs actually requires, onto the practical focus of the essentials common to all life. As it said, sustainable development's become a very dominant theme in environmental governance. It's now accepted by the courts. It's read into pre-existing treaty obligations that don't reference the concept. And it's arguable that here there's an opportunity for the courts to consider the ethical basis of environmental protection and build on the work of Judge Weir-Mantry to give the concept more bite and ensure better environmental outcomes. And yeah, that's it.
Excellent, thank you very much. Okay, we have lots of time. I think we have about 20 minutes for questions. We've had 3 really interesting papers, and well done, you guys. You're really all on the money here with in terms of areas that you're researching in. These really are the subjects du jour, and very different papers, but also perhaps relationships between them. I wonder, did you see those relationships yourselves between the papers? So the floor is open to questions. Oh, thank you, Stefan.
Well, I have to apologise for being late. It's my question's for you, and you might have said it before I arrived, so apologies that I was late. And it's very general. You talked about Article 3 of the TEU and the social market economy.
Mm-hmm.
And you talked about, the type of paper is balancing non-market values against market values in context of competition law. So my question relates to kind of what responsibilities within the treaty to define the EU's values and hierarchy between those values, because I don't find Article 3 myself particularly helpful. I think Nick Schumer refers to it as quite a task list. It's just a massive list of things that the EU cares about, with no real help as to which one it cares about more or less. And I think in the context of the way that those values are balanced against each other differs in different contexts. So the treatment of social policy, for instance, in the free movement context is different from its treatment in the competition law context. So I just wondered if you had any thoughts on that comment rather than question.
Thank you for your question. Yes, indeed. When the Treaty of Lisbon was still under scrutiny and was not enforced, there were quite some papers and quite some discussion saying that the Treaty of Lisbon looks more like a wish list without really providing the tools how to make some values, some founding values or main aims to implement them. And regarding the Article 3, Article 2, which puts founding values and main aims, from what I analyze in literature and studies, usually those values are never analyzed just like that. They're usually analyzed in particular context. Firstly, we start from constitutional law, and we have great pieces of Cremona, of Stiak, I think. They have a constitutional treatise written on these things, and also we have on external relations, which energy is in a way relevant to EU external relations law, and also the same author Cremona has quite some extensive works on that. Then we have what I was analyzing, the internal market kind of context, and then competition law context. And in case of balancing, what should go first, priority or hierarchies, helpful articles are Article 7, Article 8, 12, 14, which basically says that firstly at EU level, all the policies of the EU has to be consistent. Maybe it doesn't say too much, but it says that actually there is no hierarchy. That member states has to be careful, those that are implementing only competition goals, or only sustainability goals, or only that. So in my point of view, interpretation would be that basically it's case by case basis in a particular context. And when we talk about waste, we have other measures how you kind of assess effectiveness, and that effectiveness probably would be the kind of cornerstone from which you stand up to decide on how to balance as well as sustainability. So it's actually kind of a lot of philosophy behind that, and it's kind of a lot of theory. So that helps.
Yeah.
I have a question to Katrien.
Yeah.
You mentioned something about the fact that 65% of stuffing waste is actually going to Sweden.
Yeah.
So my question is, isn't it actually suggesting that the whole regulation of the thing is, or let me rephrase, maybe are we sure that it's really effective and it really works, and the symbiosis is not actually a way that we are encouraging factories to actually transfer the waste to someone else, get a subsidiary, and then the other factory is actually doing something else with it, not really utilizing it. In the same way that we actually doing with that tax, we actually caused Britain to actually export the waste to Sweden and then be dumped in Sweden instead of England. And then it's like, are we sure? Like, can we actually say that it's worked?
I think that's an interesting question, because in Sweden, the reason they import so much, or the case study I'm looking at in Linköping, they used to, for their industrial symbiosis, they used to produce all the waste themselves, but then they became so much more efficient and they didn't have the waste to support this industrial symbiosis anymore, which is when they looked at importing.
And they're actually using it?
Yeah, and they use that waste. The English waste then gets put into their local industrial symbiosis for district heating, biofuels.
That is, so it's being used. It's not like they're only doing it in order to.
No, it's not just to. There are bits that then get sent onwards to Norway outside the EU because they have more favorable landfill regulations.
Yeah, that's what I was thinking when you mentioned it.
But that's too with specific, I think, particularly hazardous waste. So industrial symbiosis is often mainly concerned with non-hazardous waste and doesn't really touch upon the hazardous waste that often that gets transported.
Okay. Thank you for all the speakers for very interesting presentations. My question is also for Katrien. So you used two case studies, the town in Denmark and Humber in the UK. So why did you choose those particular case studies, or what is the rationale for that? And why are they representative?
So I have a few case study criteria, and they're the reason I chose those 4 in total. And it's mainly that because I'm a lawyer, I needed case studies that were already examined in detail. So I was always going to choose more successful examples of industrial symbiosis because I needed that technical information there. And that already limits it hugely. Because industrial symbiosis is often present on really small scales locally, without it being labeled as such, but the information that I need, it wasn't there. And then also the language, and to be able to speak the law and have the information available in languages I could understand. But really the key factor was the availability of information about the system.
So you speak Danish, Swedish, and Dutch?
Yeah.
Oh, yeah.
My accents are questionable in some of them, but enough to read and write with.
Good for you.
Sorry. Yeah, sorry, I feel like you're getting a grilling, but it was a really interesting paper. I'm just, as someone who's from the Humber region, it's particularly interesting for me. And I just wondered if there was any, this might be totally irrelevant, but is there any impact in terms of the relative wealth of the regions, in terms of kind of the amount of investment there is, like publicly, for instance, in the development of industrial symbiosis? Because you said the Humber region was kind of behind the Danish region, the Humber region is quite poor, so I just wondered about that, and also what kind of soft law mechanisms might there be to deal with that. You talked about Horizon 2020, but I wasn't sure about that.
So your first question, so Kalundborg is where there's the most information, where they've done all these assessments, and there they found that having industrial symbiosis has enticed companies either to their region or has stopped them from leaving. So the industrial symbiosis there has been around since the 60s and has slowly developed and become bigger. And some of the companies in that time have thought about leaving. I think in the 90s, many considered moving to Eastern Europe and moving their factories there. But it was the fact that they were sort of in this system, and they renegotiated some of their exchanges that made them stay in the end. And it's also because it's a huge source of job creation there, it has helped the Kalundborg region a lot. I think the Humber region will, I think it'll have less effect because they're also quite different. Kalundborg is very centralized and all the companies are very close, while the Humber region, it's loads, that was only part of the map. If you were to map it, it'd be much wider and bigger, so it's harder to pinpoint the exact benefits. Also because companies are often very protective of their, just whether there are any financial benefits, so it's not often widely known. Yeah. But, and that was interesting in Sweden actually, because in Sweden they let you see the contracts between the companies because they're such a trusting society. But then I'd asked in Kalundborg, and even though I thought they were Scandinavian, so quite trusting as well, but there it's a big no-no. And then Horizon 2020 is more EU level, where for research teams, and I use that software. Yeah, yeah. So because I think a lot more is on an informal level, because industrial symbiosis specifically isn't regulated, as I'm sure there is legislation. It's a lot more policy documented oriented, often through these strategies being promoted through these policy documents. So much that helps.
Good, can I, oh, go ahead. Just one more question, as a follow-up to Rita. In terms of values, I just want to know how can this be upheld or implemented in a coherent manner between member states if they always have Article 1942
of the TFEU to justify, you know, why they're pursuing whatever it is as far as their energy mix is concerned. Does that make sense? So in other words, for example, if one of the values might be security of supply or diversification, how is this implemented if Article 1942 states that the union's energy policy cannot be pursued in a manner that impinges on the sovereign rights of a member state to exploit its resources or choose its supply of energy? So my question is, how can they uphold these values if a member state can always refer to 194 as reason to justify why they're not upholding that value of security of supply or you know, coherence in the diversification?
To rephrase it, you refer to one of the risks I mentioned, that consistency of policies by applying one of the market value, security of supply, for example. Well, that's the risk. That's the trick here, actually. And the thing is that such big projects like nuclear power plant, LNG terminal cannot just go unnoticed. They are noticed by the Commission or market participants, but actually they're quite big energy infrastructure scale projects and contracts, funding schemes, which are big at a scale, but they just get through because, for example, firstly, market participants does not have sufficient resources to actually identify that there was some kind of infringement of competition law or impediment of internal markets rules, and there it's where, to my point of view, the energy policy provisions in a way puts it in a different perspective, those traditional accountability measures of applying competition law and applying internal market rules. And that's why what I'm doing in my thesis in general, I was just giving some theoretical background and taking very small, two exact examples between particular goal. I'm actually doing a whole index comparison of different market and non-market values within EU framework, and I'm doing for comparative analysis to actually find out where member states stand. Because we have that informal reporting of notifications of state aid, and we have informal reporting on implementation of liberalization packages, but actually there are many other things going on which are unnoticed and pursued because of public service obligation. And members even don't need to notify most of their measures or their funding stuff. So what I'm doing, I'm actually trying to bring more attention to member state measures without actually giving kind of a priority when it is bad, but member states do. No, not at all. I'm not urging for more EU regulation or something. It's just that, from my point of view, in EU energy policy is bringing some new risks and requires some kind of reconsideration of those accountability measures I just mentioned. If that's answered, you could just get. I listened to your presentation, but I had to leave at the moment, so I also have some questions. So we could discuss it more on the lunch.
Right. I'll take Chair's province then and ask you a couple of questions. I'll start with you, James, because you've been neglected so far. That will end now because I'm going to rant at you for a few minutes. This is that's a super project. It's a project after my own heart, actually. I've just finished writing a paper on sort of international courts and tribunals and how they contribute to the distribution of justice. And one of the things that struck me with your paper, and you've already seemed to have started, is that it could, or your thesis could be a real contribution to the kind of critical account of international courts and tribunals. And what I mean by that is you're already doing the critical from the perspective that we have this human-centric approach to understanding the relationship between law and the environment. But further to that, and this is where my question lies, the concept of sustainable development, you rightly said, is very vague. but it also has a long history, doesn't it? Development as a phrase, and the sustainable. So I wonder what the relationship is between sustainable and development. Is development understood in that phrase a development that gestures to the entire world, or is it the development that we're now very accustomed to, that's used to sort of economically deprive the developing world? So development, there's a lot of good critical literature in international economic law on the way in which development has really, through environmental law, through international law, including international human rights law and international economic law, has really held the developing world to ransom. So development is actually its opposite, anti-development. And I wondered whether or not, to what extent is sustainable development related to this sort of history of the West versus the rest in terms of economy and development. So have you thought about, I guess I'm asking, have you thought about what is the development in sustainable development? What are they talking about?
Yeah, it's something I consider slightly and well considered further, and it seems to be used to mean a lot of different things in different contexts. And the idea of sustainability has an extremely long history. I referenced Bosman in my talk, and he released a piece in 2008 about the history of sustainability, tracing it through German forestry law and onwards. In terms of sustainable development, sustainability is often seen as a way to limit development, I suppose, or constraint on development, especially in the Western perspective. And when that's taken to developing countries, then it can be used as an argument against further development. And obviously, a lot of those reasons in say climate change negotiations, where developing countries want to progress and see the rest of something's waiting for. Western countries sustainable development needs to take into account environmental considerations, and it's also quite that's the work. It's about Kunz and their work on ecofeminism, which looks at the idea of anthropocentric focus. It's just another form of oppression, and we need to move away from that and take into account more ecocentric considerations.
Nice. It's a really interesting project, and I would really encourage you to pursue that sort of sustainable development as a way to keep the developing world from not developing. Again, another new way. I have one question for you as well, if that's okay. We still have a few minutes. My question for you is more when it comes to international environment. I'm an absolute international law and law skeptic, but when it comes to environmental law and energy law and all of these things, I become a utopianist and idealist and think we can sort it all out. If we use the law, that'll do it. So when you were talking about the production of waste, the disadvantage being that it doesn't discourage the production of waste. I wondered, in your work, are you thinking about the other side of that? Because it strikes me that that's exactly what international environmental law is building to do, and climate change treaties, not necessarily successfully, but their aim is to stop the production of wastes of certain kinds. So is that something you're exploring as a sort of, okay, we have this disadvantage, but here's possibly a way in which we mediate that? Small question.
I think I am addressing it when I think about the concept of waste, because in some cases, if waste is used in industrial symbiosis, it isn't actually waste anymore, instead it's called a byproduct. So in that way, because it's swapped that classification, you're preventing the production of waste because it's no longer waste, but the same is still being produced, just it's now called something different. But I'm not really looking at prevention or reduction of that material use as such.
Good, thank you. You kind of answered my question. I was going to ask you where this fits within the broader thesis, because energy law, not that I really know this, but it strikes me that The very last thing on your slide, on the conclusions point, was sort of the other value, this new sort of climate change awareness, not new, but relatively. It strikes me that that's the underpinning sort of factor in energy law now that ought to be taking precedence. But so I was going to ask you if you're dealing with that as but you're more interested in the values part than the energy law as such.
Is there, I cannot say that now that I know that actually energy law is a core of that. But inevitably allowed in constitutional law. So it's part of regulation. So it's between regulation, energy law, and the constitutional law. So my literature review is really huge. It's huge.
Any further questions? Great. I mean, I don't know if you guys are familiar with the REF, but you'll all be snapped up for your impact and that your research is going to have that and the like. So really well done. I enjoyed all 3 papers, and I think we can, unless you have anything you wanted to add or ask each other or sure.
So I was just wondering, because you spoke about the 3 pillars and then also thinking about the future and balancing it with the present, whether in the current context of climate change, whether there's an emphasis shifting to looking at the future and the impacts of climate change and making sure that's the reason why climate change should be addressed and using sustainable development pathway.
Yeah, I think it's a core element of sustainable development that we need to lead towards future generations, but in practical policy terms, it often seems to be overlooked.
Yeah.
It usually seems to be that there's consideration of economic development versus environmental protection, but the idea of leaving suitable environment for future generations often isn't considered as much. And yeah, for the climate change negotiations, it's a key consideration.
Seems like kind of 100% in itself. I mean, don't we want to leave a nice planet for the planet's future rather than the future generations?
Yes, and that's, I think, why some of the criticisms of anthropocentrism maybe fall down touch, because if you do take an anthropocentric perspective, that doesn't mean necessarily that environmental outcomes will be bad, because we want a decent, healthy planet for humankind to exist fine. I think the problem is it often doesn't come along with either community focus or a holistic worldview, so it doesn't take into account everything. And in terms of developing countries, as the point you raised earlier, it can focus on the Western world to the exclusion of others.
Yeah. Good. Shall we call it a day? Thank you very much, all. Oh, we have these. Rita, thank you very much. James. I'll see you guys at lunch. I might have to catch you for more of a run.
Because my starting point is that I just feel so like but if you have industrial so that's the assumption, not always true.